Any mention?
Please, Lordship. Lordship, I beg to move a mention memo for listing of a matter tomorrow for motion, my lord. It's a tender. The tender will open day after tomorrow.
Please, Your Lordship. I beg to mention item number 31, my lord, for 2 weeks. I've spoken to my friend from the other side, Mr. Sen.
Which one? Roger Hajong?
My lord, I'll argue after 2 weeks, my lord.
Why 22 matter? What's the matter about?
Well, I'll argue about it after 2 weeks. Some difficulty today.
Obliged, Your Lordship.
Much obliged.
After 1 week, yes.
Please, Your Lordship. Your Lordship, I beg to mention item number 30, Your Lordship.
Sikandar Ali?
Yes, Your Lordship. On behalf of the respondent.
For whom?
Respondent number 3, Your Lordship.
Also, petitioner. No objection?
No, yes.
1 week.
All right. May please, Lordship. I beg to mention item number 19 and 20, Your Lordship. I have informed today both the parties, Lordship. I am both a private respondent here.
Item number?
19 and 20. This is the same connected matter, my lord.
Same matter again you're mentioning.
No,
Why?
I have only some personal difficulties, Lordship. After 1 week, I will definitely argue without fail, Lordship. Maybe record it because I have only some difficulties, my lord. Otherwise, I am ready. Lordship.
Yes.
Lordship. Much less, Lordship.
May please, Your Lordship. Your Lordship, I beg to mention item number 28.
Number?
28, Your Lordship.
'27 and 28 are same matter, Lordship.
What about 27?
In item 28, Your Lordship.
What about 27? Connected?
Yes,
Connected
connected.
matters.
And what about 27?
Then it can come after 2 weeks.
Then 27, we'll take up 27 and adjourn 28.
It can come up after 2 weeks then.
2 weeks, 27, 28. Mentioned on behalf of, mentioned by respondent in 28. As matters are connected, let's vote these matters for 2 weeks, yes.
Obliged, Your Lordship.
Lordship, I beg to mention item number 21. Lordship, I pray if this matter can come up after 2 weeks.
Where Dr. Mozikar? Other side?
Lordship, this is on behalf of conducting counsel A.R. Pasa.
1 week, yes. 21 only?
Yes, Lordship.
Yes.
Highly obliged.
Lordship, I beg to mention item number 22.
Who's the petitioner?
Lordship, no objection, Your Lordship.
No objection, supposed to finish up this matter, correct?
Yes, Your Lordship.
1 week also, 22.
Lordship, Lordship, I pray after 10 of May, Your Lordship.
After?
10 May.
Okay, after 10 May, senior counsel's authorisation is for the petitioner, yes.
Highly obliged.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 29, Your Lordship. Your Lordship, I pray that the matter may come up after 1 week, Your Lordship. The conducting counsel is indisposed, Your Lordship. The conducting counsel is indisposed, Your Lordship.
Mr. Mumin?
Yes, Your Lordship. After 1 week,
the
Your
matter.
Lordship. After 1 week, Your Lordship.
My Lord, let it be 2 weeks, my Lord.
Why?
Because the current counsel, Arkin Khawalang, is having some... He'll be quite busy, my Lord.
You're quite busy doing what? Doing other cases? 1 week, yes. That's not an excuse. Quite busy, yes.
Highly obliged, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 25.
Earlier also they sought time several times.
Lordship, here in this case, they have filed, government has filed consolidated affidavit. We will be filing counter affidavit in this regard.
No more rejoinder?
Because only for the same affidavit, making one affidavit only.
1 week, no rejoinder permitted, yes.
Highly obliged.
May please, Your Lordship, I beg to mention item 26. Lordship, I'm praying that this matter may come after 2 weeks.
Yes?
Lordship, I'm praying for that this matter may come after 2 weeks.
No objection, Lordship.
2 weeks, okay, yes.
Highly obliged.
Highly obliged.
Daily list, item number 1.
Please, Your Lordship.
What matter is this?
This was the matter, my lord, where the Truckers Association wanted to set up a check gate at West
Ah,
Khasi
yes,
Hills,
you want to go beyond your jurisdiction.
Lordship, my instructions are that there is an amendment. However, they could not come and give us a copy. I'm praying for some time. We'll
You
produce
withdraw it. What amendment? They're filing for amendment now?
No.
When
It's
have
already
they filed
there.
for amendment? Tell the court.
They said it's there. They are yet to come, my lord. I'm praying for 2 weeks' time. If not, we'll take necessary
The
steps.
court's been kind enough to you on the first occasion. You've come with a petition which is half baked.
No, we had
Yes.
asked from them, my lord,
Your
because of
petition's
the
half
election,
baked,
they
it's not to
couldn't
be
come.
eaten.
I completely
Right?
understand. I
Then-
completely apologize, my lord. Kindly give us 2 weeks' time.
I'll give you
if
3
not,
days time. Just a matter on
a week, a
Monday.
week's time, my lord. Do they need to come and give it?
Monday. If you are serious enough, you would have brought it today.
No,
if
they
it had
could
been
not
done
come and give
prior.
it, my lord, because of the election and all. They said because
Item
from
number 2.
government.
Well enough, yes.
Monday. Obliged, lord.
Yes.
Is that petition under section 29A, my lord? Lordship has passed a judgment yesterday, my lord, where Lordship has made it clear. To an extent that, my lord, if the appointment is made by the High Court, then, my lord, Lordship has the power to extend.
If the context requires.
My lord.
Yes, so what do you want? You dispose of?
Well, we can, if, I think we are on the same page.
The judgment. You have a copy of the judgment?
I have a copy, just one copy.
Yes, sir. Very difficult, the judgment.
My lord, I'm sorry?
Very difficult because from all over the country, they're all conflicting judgments.
Especially from Bombay, my lord. This is a very recent one also. My lord, if I can just place one.
Bombay? I've not seen that Bombay judgment.
This is 2024, my lord. KIPL infrastructure. Very similar to our case.
It says also contextual.
It says the same thing, my lord. If the appointment is made by the High Court, then otherwise.
Okay. Dig down to. But why do you want 1 year? 1 year?
My lord, 1 year, my lord, because
You see the matter, three final arguments.
3 different dates have been fixed, my lord. In case we are not able to, quite a voluminous matter, my lord.
So this is an application under section 29, capital A bracket 4 of the Arbitration and Conciliation Act 1996. Where's your prayer? Praying for extension of time for making the arbitral award by a period of 1 year with effect from 4/4/2024. Stop. Next paragraph. The brief facts are that the petitioners, you had a preferred option for appointing arbitrator.
I'm sorry, my lord?
You had preferred the
Lordship, I have.
Section 11. The petitioners
High Court
had
appointed.
approached this court with application, had earlier approached this court with an application under section 11 bracket 4 and bracket 6 of the Act for
Order is at page
appointment
18,
of arbitrators, and the same was registered as arbitration petition number 1 at 2021. The matter was then disposed of by order dated 17/3/2022, directing the nominees appointed by the petitioner and respondent to decide on the presiding arbitrator. Stop. It appears that those preliminary hearings were held on 21/4/2022 and thereafter the same could not be completed with the time provided. And the mandate was then extended by the tribunal by order dated 11/8/2023.
My lord,
20 by order so for a further
page
period of
81,
6 months. 6 months with the consent of the parties till 4/4/2024. Stop. Next paragraph. Mr. K.S. Gautam, letter counsel of the petitioners, submits that though the arbitral tribunal had extended the time for 6 months, the proceedings could not be completed within a set extended period. And presently, the matter stage final arguments.
Final arguments
is fixed at the stage of final arguments, and the next dates in the matter are fixed on. Is it 3 dates?
Well, there are 3 different dates. My lord, 15/7,
15/7,
15/7, 16/7, and 31st.
Are fixed on 15/7/2024, 16/7/2024.
Well, 2 dates. Sorry, my lord.
And 2024. Stop. It therefore prays that orders be passed under Section 29A4 for extending the mandate of the tribunal. Stop. You, Mr. Pasa, you have no objection? Or Ranja, sorry.
Actually, my...
I am appearing on behalf of the chief engineer.
Yes.
The only one thing has to be considered in this matter, Milords, as such we don't have any objection for the extension.
Yes.
But keeping in view, Milords, the order judgment which has been passed by your lordship yesterday,
yeah.
Whereby it has been held that as far as matters where the appointment has been made by the parties, there the jurisdiction will be of the district court.
Yes.
So, Milords, in this case, what has happened is, although the Section 11 petition was filed before this honorable court, but the parties had in the interregnum appointed an arbitrator. So that aspect has to be considered, Milords, as far as this case is concerned.
No, but the thing is that there are orders from this court saying that the nominees of the parties were to select their own arbitrator. That's what you mean to say. So you mean that the High Court had no hand in appointing any arbitrator from any panel. Is that your submission?
Yes, Milords, that is the submission, because the appointment was made in the interregnum by the parties, and that has been recorded in the order section.
In the petition?
Well, I think he's reading from the order, page 18, my lord.
Page
18. Now, well, if they say that the parties have appointed the arbitrator, my lord, here.
18, the order of the court, yes.
This is the order of the court, my lord. Had the parties agreed to appoint an arbitrator, my lord, we would not come to the court in the first place. After we came to the court, they even filed an affidavit also, and subsequently, my lord, they said that we agree to nominate one arbitrator from our side and one from their side. So, my lord, both these arbitrators have appointed a different arbitrator. So, my learned friend cannot say that this appointment has not been made in terms of Section 11 of the Arbitration and Conciliation Act.
Yes, okay. Yes, Mr. Yes, Pandey, on behalf of the respondent, submits that though you have no objection if the mandate is extended by the court.
No, Milords, I have no objection towards the extension.
There are no objections with regard to the extension of the mandate of arbitral tribunal by this court. The only point to be considered is that whether this court had in fact appointed the arbitrators under Section 11(6) of the Act to make the order passed in CRP number 2224 in the case of so-and-so applicable to the facts of the present case. Stop. Like we heard the counsel for the parties. Stop. As submitted by the counsel for the petitioner, this court by order dated 22/4/2024 passed in CRP so-and-so, the case of so-and-so had which paras?
Yes, it is in para 20 will be relevant, my lord.
From?
Para 20, my lord. Their lordship has stated that...
21 nothing.
Para 20, my lord, 20. Yesterday's judgment, para 21.
No, para 20 is a short paragraph.
No, but there basically lordship has come to a finding that, say, my lord, in this particular case, no appointment was made by section 11, my lord. On the basis of section 11. Otherwise, even the judgment of the Bombay High Court which I have placed, my lord, KIPL Vista Core Infra Projects Limited. There, my lord, paragraph 66, 67, 68 and 69 is relevant.
Then we'll quote para 16, 17.
My lord, of
18.
course. Well, in conclusion, lordship has mentioned in section in para 20 that, my lord, in this particular case, the question
16 to 18 may be relevant.
Yes, Tom. Tom?
No, I didn't talk.
PRP number 2 so case also had observed that
19.
with regard to the expression quote used in section 21E, the same is interpreted by making use of expression within quotes unless the context otherwise requires. Stop. Para 16, 17, 18 and
19 also.
and
that's
19
right.
thereof which are relevant are reproduced herein below. Stop. Next paragraph. With regard to the submission of Mr. Pandey as to the fact that there was no effective appointment by the High Court of an arbitrator under section 11.6, approval of the order dated 17/3/2022 passed in pass an arbitration petition number 1 at 2021. It is observed therein that certain directions have been issued with regard to the nomination and appointment of an arbitrator by the parties. So in this view, the matter as the High Court had passed orders in application of section 11.6, applying the judgment dated so and so as also, which judgment is this? As also a judgment cited by the
KIPL.
Correct, it's the same point.
Same, absolutely correct. But lordship will just see paragraph 16 onwards.
16?
17, 18.
I'm sorry, 66, my lord. 66, my lord. I'll have already flag marked.
What? The Bombay, I've been informed that the Bombay High Court matter has also been referred to a larger bench.
Yes.
So I think Milot's judgment would be sufficient.
Okay, yes.
Well, it's very similar to the one lordship is.
Yeah, in the interview center, this court will have jurisdiction to pass orders for extension of the mandate of the arbitral tribunal under section 29A bracket 4 of the Arbitration and Conciliation Act 1996. Stop. Next. Accordingly, this petition is disposed of with the direction that the arbitral tribunal's term shall be extended for a further period of 1 year, Mr. Pandey, from 4/4/2024, with effect from 4/4/2024. And the petition offering stands closed and disposed of this.
Highly obliged.
Obliged.
Much obliged.
Item number 3.
You should have cited the judgment. Oh no, you're not the other case. Why?
So I'm
Who
praying
is
for
the respondent?
wife Yutika Pallavi, Your Lordship.
Who?
Yutika Pallavi. She's having some personal difficulties, Your Lordship.
Lordship, this is that matter
Is
where...
there evidence today?
No, my lord. This is that Order 7, Rule 11 issue.
I remember you raised the objection regarding that who's the stamp reporter at that point.
So they are the petitioners. They finished the submissions. I have given my response. They sought some time only to respond on the limited law points. My only fear is that, my lord, the issues may sort of fade from lordship's memory. If they are asking for time,
if they have not already faded, yes. I've seen the adjourn application. Adjourn for reasons stated therein. Just on
next week, my lord.
Just after 1 week.
Obliged.
Item number 4.
Yes.
May I please, Your Honor. This is in regard to the pension, my lord.
Why can I accept nomination? What happened?
Lordship, there is no document to show there was no document to show that he has divorced the first wife. Because change of nomination can only be effected on 2 grounds, Lordship, 2 accounts. One, if the death of the first wife, then the name of the second wife can be entered in the form of nomination. And secondly, if there is a degree of divorce.
No, he's the employee, correct?
Yes, Lordship.
I'm still alive, my lord.
Now, so far as the release
still
of
alive also.
rule,
No, your pension you're receiving now?
No, I'm not receiving any pension. That is that one is stopped due to the objection filed by the wife.
So now, why by your second wife?
First wife filed.
You got a new wife now.
Yes,
my lord.
Divorced your first wife.
No, my lord. We were. She deserted me for a long period, my lord. For 7 years, almost for 7 years.
Then?
So that happened, my lord. I cohabited with the second wife, and I have children also. Now,
Show
question.
the law whether it can go. You put your children then as nominees.
I have put the children. My
You
lord.
then take 50% you have to give her also, like it or not.
That is
the first wife.
That is a question will come, my lord, after my death. After my
After your
death.
death,
Now I am starving, my lord. I am not
let the
receiving.
pension be released to you. After your death, then
After
you still haven't divorced
after
her,
my
then you
death
give the 50% to you. Yes. You're not divorced.
As per children has got the right, my
You deserted him.
This is a void marriage, my lord.
Void marriage, the second marriage.
The second marriage is a void marriage.
Of course, it's a void marriage. But the thing is that now, if the author doing anything but bigamy, we will not overreach. But the thing is, when are you going to you retired?
Already.
I'm already retired.
How old are you?
I'm now 62.
Then you got a long way to go then. So you continue enjoying pension. Meanwhile, you do something. If you want to change nomination, you do.
No, I have given
release a pension, and then subject to outcome of after his demise, then we put an order that 50% will go to his first wife.
That's the course of law. Even children are eligible to get married.
50% go to children.
Children are eligible to get. That is a law. That is not denied, my lord.
Yes.
But presently, my lord, I am eligible.
How can you twist the arm of the law now to register your second marriage through the nomination?
My lord,
you don't have any material support the fact that yes, I am divorced on the first wife.
There is no.
You start divorce proceedings then.
That still I have a process, my lord. I can do it. But that is a separate issue, my lord.
You don't want to divorce also.
My lord, I'm already deserted for 7 years. No connection.
Then desertion is the ground for divorce.
And even my lord, when I was getting my salary.
See, we can't stretch it, Mr. Nath, to allow a petition that to register a nomination of your second wife. We're not divorced
my
on
lord,
the first wife.
that a prayer is to release the pension, lordship. But what happened, lordship? He has filed 2 sets of nomination. One in 2016, lordship. That is at page 8, lordship. That is the nomination of the first wife. And subsequently, he has filed another set of nomination. That is why we could not release, lordship. So if we are not opposing.
Yes, my lord. Thereafter, we have filed a final final nomination.
First nomination, page number 8 in my counter affidavit, lordship. Annex 2, lordship. The date is 12 May 2016, lordship.
12 May.
Page number 8, below down, lordship.
Now Annexure 1.
Annexure 2, Lordship.
Your respondent number?
I am 123, Lordship.
State respondent.
State respondent.
Okay. Annexure 2.
Yes, Lordship.
This is affidavit.
My counter affidavit, Lordship.
No, affidavit is okay. Where is the page number? Okay, sorry. What's second affidavit? Page number 8. Yes, name of the members of the family. Sapin Brahm, you are the petitioner. Sumi Burman's whom? Daughter
From the
Mimi
first
Burman.
wife, no?
First wife.
You are Sankari Burman.
Shankari Burman.
Date is 12 May 2016.
Yes.
Subsequently, Lordship,
Then
he has submitted one set of nomination, that is at page 11, Lordship.
now you married to Koilani Rai.
Yes, ma'am.
That was the reason we could not release the pension, Lordship.
Thereafter, my lord, we were asked to file a final nomination papers. So we have filed final nomination papers, my lord. And
Well, you
thereafter,
file final nomination papers, but you show that to change your wife, you have to have adequate papers for the authorities to change.
On 19 of last month, my lord.
Yes.
They have filed final nomination, my lord. On 19 of Annexure A of the affidavit, my lord.
Whose affidavit?
Petitioner affidavit on 19th of March, my lord.
When do you retire?
22/10/22. And there is a miscellaneous case also pending, my lord, whereby I was paying the maintenance regularly. But after my retirement, when I am not getting any...
I am not getting maintenance since
please
last
let me
November.
Let
my
me
lord. Yes,
get your chance.
Yes.
So, after my retirement, even after my retirement, some days, some months I paid, my lord. But later when I have no earning, I am not getting any disbursement also, I could not pay. It is admitted fact that I had been paying them 10,000 rupees per month, my lord. And final, on the nomination, my lord, nomination is a process for the state respondent to
What can they
initiate.
can they accept nomination of your second marriage?
That is,
Recognize it?
that is we are with the court, my lord, before the court, my lord, for
So
this
before the
purpose.
court, this court can grant divorce.
No,
Then we'll hear it. Otherwise, if you don't do anything in the intervening period, we'll post out 1 week. You take a choice. Otherwise, the order will be like that.
No,
now
that-
you have two
that-
daughters
that
from
part-
two daughters from your first marriage, two daughters from I saw two
Yes,
daughters
my
from
lord.
second marriage also.
So that my lord, after my death, all the children are equally they are eligible, my lord. That is admitted fact.
Until
but
they
presently
25.
my pension is a
There's
question.
a
my
matter
lord.
for 1 week. For it's in the hearing list, admission hearing. Was the admission hearing today?
No, today is for in order.
In order.
In order.
Orders.
Orders.
Yes.
Also final hearing, Lordship.
Stop that. This is a matter for final hearing, as a fixed matter after 1 week.
God bless.
Item number 5.
As we can dispose of now also anyway.
It's a question of pension only.
Pension is only, but you're a twisted pension, not a question of. The construction is complete.
Yes, completed, Your Lordship, but I need some time to draft the rejoinders.
But the previous one's not further 2 weeks' time. File a joint
Lordship, I am appearing for respondent number 2 on behalf of Ms. P. Agarwal.
Very good, yes. Noted. Note, Nikki. Yes.
6.
6 also, Your Lordship.
7.
Oblige.
my lord, have a prayer. I need 2 weeks time, my lord, to file the rejoinder, because I was, for a few days I was not available for my personal difficulties. I could not.
2 weeks time is prayed, allowed to the petition to file.
I'll bless.
8.
The same prayer, my lord. This is also, I have to file the rejoinder.
Napoleon?
Yes, my lord.
Yes.
Affidavit has been filed. I'll bless.
9.
My lord, the affidavit is ready. We will be filing in the course of the day, my lord.
Mr. Judge submits that the affidavit have response and final course of the day. They've served a copy on you?
You will be serving.
Just after 2 weeks for rejoinder, if
Much
so
pride.
advised.
10.
I didn't. Then also, Your Lordship, it's connected, Your Lordship.
Then also you filing today?
That is at the council.
Mr. Sima.
Who's appearing for respondent? You're appearing, same case?
No, Your Lordship, it's same prayer. It was
Same
connected.
prayer?
Yes, Your Lordship.
Then?
Yeah, the council is Mr. Sangma, Your Lordship.
Count of Senate file? Yes.
Lordship, item number 10 is also connected with item number 9.
You're not filing affidavit?
Yesterday only I have received the instruction, so I may be allowed 2 weeks time to file affidavit.
You file it then, yes. EM Samas submits that the instructions you will receive. He prays for up to 2 weeks time to file.
11.
May I please, Your Lordship? Lordship,
Have you filed a rejoinder?
Lordship, we request some more time to 2 weeks time to file.
So, coach.
Yes, Your Lordship. Here, final report has been submitted by the IO, which in regard to the FIR filed by the complainant, where the allegations were made against the respondent number 5, Your Lordship. So we have applied for the certificate copy of the final report.
So, this is matter after 2 weeks. Yes, respondent number 5.
File affidavit.
As also, huh? What about state?
State we've already
state,
filed.
yes. This matter of 2 weeks. In the meantime, petition to file rejoinder as also respondent number 5 to file affidavit.
Item number 12.
May it please Your Lordship. Lordship, this matter, we have filed a miscase for impleadment. Against that, my lord, the writ petitioner, they filed their response.
Where's your...
Yes, Your Lordship, we're filing the additional affidavit to refute the allegation made here in Your Lordship.
You're filing today?
No, Your Lordship.
It's already been filed.
No, so they have filed that...
Objection.
Your Lordship, they have filed in impleading. They have filed
yes.
rejoinder.
Yes, you file a reply to that.
Yes.
They already filed.
They have filed a reply.
Objecting to your impleadment.
Yes, my lord. And against the reply, my lord, we have filed a rejoinder. Now, what I understand, if I'm correct, is that they want to file a further...
No.
Your Lordship, I humbly pray the matter may be
tomorrow
possible for the day, since the conducting council is not here.
Lordship, if that is the prayer, well and good. But tomorrow, my lord, there's some difficulty. I'll be out of station for about a week, after 1 week, my lord.
In the meantime, the interim order may be allowed to continue.
Yes.
Dated 1/2/24.
Yeah, as the conducting council, we have the petitioner is not present. This is the matter after 1 week. Interim orders pass as continue next day.
Item 13.
May I please, Your Lordship? Your Lordship, I am praying for 3 weeks to file my counter affidavit.
How many times you asked?
2 times.
Yes. Your name?
El Majal. El Majal.
El Majan. Ms. El Majan, we have respondent pays funds allowed 2 weeks time to file affidavit. This is thereafter.
Item 14.
This case, Your Lordship, we filed the affidavit.
I've received the affidavit, Lordship, and with regard to Respondent 6, we have taken steps, Your Lordship.
You always speak quietly, so softly, you speak up.
Lordship, with regard to Respondent 6, we have taken steps on the last occasion, Your Lordship.
I'm entering appearance, Lord, for Respondent number 6.
Yes, Mr. Karan Nambari's entered appearance on behalf of Respondent number 6. It's also submitted by MS T. Yangi Leonard EAG with so-and-so that the affidavit has been filed. Then, what do you want? Affidavit you'll file?
I'll file an affidavit.
Responsive praise funds allowed to file an affidavit. As also rejoinder you will file?
If required, my lord.
Yes. Responsive praise for Mr. P. Nambari have R6. Praise for 2 weeks' time to file affidavit. Rejoinder also to be filed by the petitioner.
If so advised, my lord, because I...
If so advised, and rejoinder also be filed to affidavit of the state by the petitioners in the meanwhile. This accordingly.
15.
Please, Your Lordship.
Yes.
Your Lordship, as per last order date, the state
What instructions? What's the matter about?
Termination of service, Your Lordship.
Yes. Where's the Government Council?
Your Lordship, Miss Espert charges on legs.
What instructions does she have?
Your Lordship.
I don't see it on legs, yes. I can see her walking around. Yes. Yes. What instructions you've got?
Your Lordship, I am yet to receive instruction.
Why?
Because
when was this matter moved? 1st of April.
1st of April.
Because I have already forwarded everything, Your Lordship, or parawise comment and all. So 1 week time may be given, Your Lordship.
Yes, it's from Shillong only. Yes,
But from the office, Your Lordship, I am yet to receive.
the office is in Shillong only, it's just nearby. As prayed for 1 week for the time out to the learned GA to obtain instructions. This thereafter and so and so.
16.
This is Your Lordship. Lordship, in this matter, we need some more time, Your Lordship. We are yet to receive the instruction as directed.
Please, Lordship, may I just submit only 2 things, Lordship.
The non-registration of FIR?
No. Register, FIR has been already registered.
FIR has
only
been
my
registered.
submission is that in the FIR and also the complaint by NOCMA of the Dorakri, where the petitioner is teaching in the school, and also the victim, here is the petitioner. They have clearly mentioned the name of the private respondent who have really trust and involved in that incident. The case is very serious. I pray, Lordship, that no, this may be issued to the private respondent also, Lordship.
At least a week's
No,
time.
not now.
Lordship.
Not
A week's
yet.
time can it be...
Without disposing of on... should I praise funds allowed 1 week's time to obtain instructions?
Lordship.
Further 1 week's time to instructions. It understood that the next day instructions should be received positively.
Lordship.
Apply, Your Lordship.
That's place, Lordship.
Supplementary list. Hearing item number 1.
Mr. Jha,
My lord.
you've heard of those lands, which are fictional, like what's those fictional lands that you have, in folklore and in fables, and stories. I think this place is somewhere like that, Atlantis, or something like that. What do you want to do? The place doesn't exist.
My lord, in fact, I got some more material. Further reinforce.
I think we have to ask for a thorough investigation. Southwest District, Southwest Subdivision, Pragya.
Pargana, my lord.
No, Pragna.
This is from official website of the district, my lord.
Subdivision blocks: Alipur, Boripur, Diamond Harbour, Canning. Municipality, Boripur, Basanti, Bangor. South Prince, yes. South Prince, Alipur, Baripur, Canning, Diamond Harbour, Kakdweep.
Only 5 citizens.
What to do?
My lord,
We dismiss it.
my lord,
But if you know, this is a very serious matter, in fact.
my lord, even coming on the merit, my lord, why I have annexed a letter from the respondent itself, my lord. Why they were worried about not conducting? They themselves said that to conduct an additional court of inquiry, my lord. They have not done. They have not.
No, on the merits first, your very basis
My lord.
on furnishing your discharge was due to furnishing of a false document.
My lord.
Correct.
My lord.
And then that document you've annexed here in your petition also.
My lord,
The patent is patent on the face of the document itself. After going through, finding there's no such subdivision. Then how they have been even rightly been discharged? In fact, you should have been dismissed from service.
My lord, that's
without any.
My lord, that amounts to dismissal itself, my lord. Discharge 8 years of service. He will not entitle for any.
If you enter service on the basis of a forged document, what kind of concession do you think should be shown to you? You think you deserve any mercy?
My lord,
if you enter service on the basis of forged document, you have deprived some other rightful poor person who wanted to be a Jawan from serving the country. Otherwise, you would draw it, Mr. Jha. Otherwise, you will have to pass some orders. You take instructions to your client. Otherwise, when the matter is taken up today, it is clear that the certificate annexed to the affidavit to the writ petition at
next to 3 months.
Your writ petition.
Page 30, my lord.
Lecture 4, page 31. It is clear that the document indexed at lecture 4 at page 31. No, this is the one the one showing where you showed that Pragana whatever. Where's that in your petition?
It's 38, 38.
31 is the communication to Government of West Bengal saying that no such thing.
Annexing with that only, my lord. 30A, capital A, my lord. Next page.
It's not here in the writ petition.
It's also page 33 of my affidavit.
1 to 6.
Page 33.
Oh, no.
1 to 6.
Annexed, which furnished the certificate furnished by the writ petitioner, dated 24/2010, showing the same to be issued by the office of the sub-divisional officer, Southwest, Pragna. is a fabricated document, inasmuch as no such subdivision exists as per the information received by the DSGI. Stop. The European order dated 27/9/16 also reflects the same position, to show that the letter, not the impugn letter, a letter dated 27/9/16 issued by the government of West Bengal also reflects the same position, that the said certificate was not related to the office. From this view matter, to avoid any further adverse orders, the council picture prays that we will have to obtain instructions within 1 week. This thereafter. I think you tell the person this is some other action might come, yes.
Daily list. Item 17.
Lord, in item 17, on behalf of the petitioner, we are filing a small counter-written argument to the written argument of the respondent.
What counter-written argument?
My Lord, the respondent had filed written argument on 03/04/2024. We are filing a small counter.
But then Mr. General hasn't finished, he said last time.
Your Lordship granted me 15 minutes. 15 minutes time. I will take less than 15 minutes.
I have issued served the copy, man.
He served me one copy just now. I have not even gone through that.
We'll give you 15 minutes tomorrow.
Tomorrow.
We will not take it any further.
Tomorrow.
Appeals.
Huh?
Yeah, but the appeals could take some.
It's okay. No problem.
Yes, Mr. Gentle, no, give it on front. Submit, I just receive a copy of the points submit on counter arguments furnished by the petitioner. He prays for some time to peruse the same. That's the matter tomorrow. As part heard, yes.
Deeply obliged.
18.
Yes.
Please, Your
My
Lordships.
Lord,
My Lord, in fact, there is urgency, I understand, Your Lordship, and the matter is posted today and no further adjournment. Only thing, my Lord, I am otherwise ready, my Lord. I am having slight problems, some throat infection, Your Lordship. If it can be posted on Monday and Tuesday, I undertake, my Lord. I'll do it.
I may conclude
Because
my
there
submission
is
today,
a
my
urgency on behalf of JHDC also.
No piecemeal submissions.
Lordship,
Hear it through, hear it through.
Tuesday, my Lord, I undertake, my Lord. I undertake, I'll do it. Only problem, my Lord, infection, throat infection.
Yes, I understand. Now everyone's having throat infection. There's a virus running around. Already be careful. Yes, Mr. S.N. Leonard, Counsel, you are appearing for the respondent?
JHDC, my Lord.
Respondent number 2, my Lord. Respondent number 2. JHDC.
Mr. S.N. appearing for respondent number 2, bracket JHDC, has bid for some accommodation due to health reasons. So accordingly,
Tuesday, man.
This is matter Tuesday, 30th.
Tuesday,
30th.
This is the matter on 30th April. How the hearing is.
Obliged.
23.
Lordship.
May I please, Your Lordship?
Lordship, the arguing counsel, Mr. Sheikh, is occupied in Oku number 3, Lordship. Pardon matter.
Do you start?
So let the matter be.
Conducting counsel is Mr. Abraham. So Your
Mr.?
Lordship. Mr. Abraham. So.
Where's Mr. Abraham?
Abraham, he's in.
Okay, you two stand then, we will dispose of the matter. What is there? Is it a service matter?
Yes, Lordship.
What is there? Yes. Let's see. What is your petition? You
Sir.
say that Home Guard volunteers.
Yes, Lordship.
I do not have the brief also.
Yes, it's fine. You can go along. Okay. You can't compel them to make decision. I understand this case. You don't have the file with you?
Yeah, it's there, Lordship.
It's there with you. What's your prayer?
For revision of P, Lordship. Pay scale 2017, where not P to the petitioner's Lordship.
Are the home guards paid by the on deputation when they deputed on duty? Are they paid? Excuse me.
Yes, Your Lordship.
The court's talking to you.
Sorry, Your Lordship.
Yes. Who pays them?
Your Lordship, I am sorry to say, Your Lordship, in this case, Your Lordship, I don't have the brief, nothing, Your Lordship. So let the matter be come up tomorrow.
And the prayer of the council petitioner is a matter of 2 weeks.
2 weeks.
Yes. You
Much
prepare the
obliged.
case and argue it next time.
Okay.
Much obliged, Your Lordship.
24.
Both the matters are, Your Lordship, connected.
32. 32.
Your Lordship, before my learned friend submits, Mr. SN is on legs, Your Lordship.
What's the matter about?
I think that socially boycott from the village. 3 houses have
Yes.
Yes, my lord, if I may. Yes, my lord, on last occasion on by order dated 22. 22/3/2024. My lord has granted permission to the petitioner to file rejoinder to the show cause filed by us in connection with this case, my lord.
I have already
Subsequently, subsequently on the last date, they have already filed a show cause, my lord, their rejoinder. But my lord, in that rejoinder, they have raised certain fresh misleading allegation against us, my lord. So I believe since these are fresh.
No rejoinder to rejoinder.
Because, my lord, they are filing fresh allegation against us, my lord. They are expanding the scope of this petition.
It'll be unending then.
Exactly, my lord. That's why what they have done, my lord.
New development, my lord. It's already an incident happens.
No, they should have filed a fresh writ petition, my lord. But what they have done, they have filed a rejoinder bringing in a record of a new misleading allegation against us, my lord. They are saying that we have obstructed them in constructing government house, water supply, electricity. All these are misleading allegations, my lord.
Rejoinder all these new things.
My lord, in paragraph, if I may take, my lord,
Which rejoinder?
To the miscase,
26.
Rejoinder
yes,
to the
paragraph 7, my lord.
I miscase. Yes.
Paragraph 7 of the rejoinder, my lord. In fact, it's not a rejoinder, my lord, it's a new allegation. My show cause is different, and through this rejoinder, they are bringing fresh allegation.
So that's the advocacy skills. Yes.
No, my
That's
lord,
why I need to.
Where is that?
Page
Paragraph 7, paragraph 7.
Page 3 of my F.
That a woman made at 8, 9, 10, 11. Just read it, Mr.
Yes.
Sona.
That amendment made at paragraph number 8, 9, 10, 11, and 12 are false, incorrect, and strongly denied. In reply, the answering deponent petitioner respectfully submit and respectfully beg to state that the stand taken by the respondent number 5 before this honorable court and the action performed by him and his dorba in the village are contrary to each other. In his affidavit in a portion before this honorable court, the respondent number 5 has made a tall claim that he, being the soldier of Maublo II, he has always maintained and made an effort to bring peace within the village, whereas his action and activities speak otherwise. In this regard, a reference may be drawn to paragraph 11 of his affidavits, wherein the respondent number 5 has categorically states and put a blame to the petitioner and their family for being dissatisfied with the Dorbar, had expressed their desire not to be part of the village anymore. The respondent number 5 further stated that the petitioner and their family has regularly availed the government scheme like MREGS, ration cards, water supplies under the Jal Jiwan missions and other beside availing free residential certificates. Whereas contrary to his statement and claim, His day-to-day activities in the village clearly indicate the facts that the respondent number 5 himself is the main person who instigates and encourages the residents of the village to create troubles and disrupt the day-to-day life, peace and security and activities of the petitioner and their family. In this connection, the petitioner will state that as on today, the present scenario within the village is that all those water supply and pipeline which was initially connected to the households nearby the house of the petitioner has been disconnected and destroyed by the fellow villagers. The electricity connections to the petitioner's house has been disrupted by the co-villagers time and again for no reason. On the other hand, respondent number 5 till date has withheld and detained the epic cats of almost all the family members of the petitioners. That apart from an act of instigating and encouraging the co-villager to commit illegal activities towards a family member and house of the petitioner prior to the decisions and orders to socially boycott the house of the and members of the petitioner by the whole village. There was an instance where the petitioner's family's members were discriminated from availing the government schemes, and in this regard...
My God, so anyway, it's a really long paragraph.
Yes.
Now, you mean to say this is not part of the initial petition complaint that you made for this court?
No, no, my lord.
But Mr. Shila said they're on the same lines. Social boycott, being deprived of the schemes, water supply being disrupted, electricity supply.
No,
Is that
no,
public
because
part and parcel of the grievance that they have against you, the Darbar?
Admittedly,
because, my lord,
in their affidavit.
if I may humbly submit, my lord,
yes.
In the original petition that they have filed, the grievances is with regard to the letter issued by the Darbar Snong to allegedly authorize them. That is the main allegation, my lord. And the prayer also, if you look at the petition, the prayer is to set aside that letter, my lord. So now we have, in my petition, I've already filed my affidavit in opposition, and they've also filed a rejoinder. They have never mentioned anything about this, my lord. Now, on just a few months back, they filed a missed case. When I replied to their missed case, my lord, now if my lord would see in this paragraph 7, they are replying to my affidavit in opposition. Not to my affidavit in the missed case, my lord. They are referring to affidavit in opposition and bringing new allegation, my lord. Can they be allowed to expound
what is the current situation now in the village?
Current
no, because,
because those police personnel are still residing.
Were they able to vote?
That I have not.
Otherwise, if you said epic cards have been withheld by the respondent 5, if that is not true, then...
Yes, my lord. And so far as the instruction that I have got, my lord, from the respondent number 5, what they are saying is this, my lord. So far as EPIC is concerned, that is between them and the election department. The election department has appointed an BLO. It is for him to give these EPIC card. That's number 1. Number 2, so far as electricity is concerned, my lord, what has happened recently, there was the village was hit by a storm, my lord, and the entire village were in darkness. Not only their house. Now they are picking this as an opportunity to hit against us. And not only this, so far as water connection is concerned, my lord, what is happening? JJM is being implemented. Pipes are being given to every household. There are some plastic pipes also that has been given, not only to them, even to many households. Those pipes has been destroyed, most probably due to the low quality. And now they are using this as an allegation against us, my lord.
Have both sides appeared for mediation? They have appeared once.
My lord, the DC has convened a meeting. We have participated, and my lord will see in the affidavit filed by the state what they have said. They have said that it is the petitioner, by using abusive language in such meeting, who are disrupting things. It's not us, my lord. Now,
is this a lady or a man?
There are 3 of them.
Yes, my lord. Three of them. Yes, my lord. And not only this, my lord, what has happened here is that they have filed initially two FIR. 2 FIR inquiry was conducted, nothing was found. Now they are coming with series of FIR, nothing is found. Now, is it possible, my lord, that everyone is lying and they are the only one who's telling the truth? Is it possible, my lord?
Anyway, we'll do one thing.
Yes.
If you agree, I think we'll bring it here for at least we'll list it again next week. The court will pass orders if this is a situation. Who's appearing for the government?
Your Lordship, Mr. SN.
Doesn't matter. This is matter of further hearing. Then we'll bring them here, the headman and the people, whatever. We'll bring to the High Court itself. Let them come for mediation.
mediation, then that will be reflected for mediation, my lord. Otherwise, because what
I'm not saying mediation under the High Court mediation rules. Mediation is just like conciliatory meeting. I'll put it for Registrar General. Let him address both of them.
Because if I may
you
just
can't go
point out,
like this. Now, if something happens, so your tap gets broken, you say they did it, and they also say if they do it, they say they didn't do it. It's like you can't have this tit for tat kind of situation.
And my lord, if I may just highlight recently what has happened, BDO has called a meeting, my lord, because there were some people who are not availing government schemes because they didn't have Aadhaar. That's why BDO has called a meeting to encourage people to take Aadhaar. No. That is a general
an issue about Aadhaar.
General.
Even
the
the
general
BDO was
happening
compelled to summon both the petitioner and the village as a whole to know why the government scheme
if I
has
may
not
just
been implemented.
be allowed to complete, my lord. So the BDO has called a meeting.
This is all right. We understand. We don't want any more affidavit, more rejoinders. We'll pass orders. Yes, this matter up to 1 week. Yes. But meanwhile, you inform your clients that High Court observed that this situation cannot continue. Number one, number two, and then that you all the parties will summon to the High Court. No, to
Let it be on other be part of that extent.
No, we'll pass next week. But before that, otherwise you have to correct your measures. You won't be. They have to be give and take. No, yes.
Obliged, Your Lordship.
Obliged.
33.
May I please, Lordship? Before my learned senior starts, if I may pray, my lord, that it's a Nokmaship dispute. What had basically happened, my lord, was that at the time of registration of the respondents as Nokmas, the respondent 6 and 7, an objection was filed by some persons. And that objection was withdrawn, and enough time was given, no objection came from any of the clan members. So they were accordingly registered as the Nokmas. After the registration, the petitioners, who don't even seem to be from that clan, had filed an objection. And then that objection was rejected,
yes.
And the matter was decided. So maybe the records may be relevant, because there was
records haven't come. Yeah, records necessary.
Lord, we have annexed important documents. Well, without the record, also, I think
which part of the record do you think is important that we call for it?
Two things, my lord, because here the respondent who has been appointed was the adopted child of the earlier Nokma. So that lineage also has to be.
The respondent who was appointed is the adopted child of the
last recorded Nokma.
Okay.
That is one part. And in their writ petition.
While they were childless.
Yes, without any issue. And the second part is, my lord, that the locus of the petitioners also is in.
Who are they?
That is not known.
They are the Maris and Chachis of the village.
The address is a different.
Of the King, no.
Different address.
Who are you?
Yes.
Well, I'm the clan member.
How are you clan member? You're a Mari or you're a
Yes, is aware to challenge the Nokmaship appointment. He has to be directly from the lineage of the family of the Nokma, my lord.
That is not the ground taken by the district council.
But the thing is that, are you espousing whose cause? In their place, who do you think, by your estimation, who should be the Nokmas in place of 5 and 6?
My lord, my claim is that private respondents are not entitled to become.
Then who will be entitled?
And the clans members are entitled. The other clan members are there.
To be Nokma?
Other clan members are there.
What other clan members are there?
What happened, my lord? There was an application moved by another stranger seeking for registration of the private respondent as a Nokma. And the two complainants from my own clan objected to their proceedings. And subsequently there was pressure, so they withdrew. After they withdraw, they register the Nokmaship. Now, I also filed objection. Now, the only ground by district council is that, by the Ilaga in charge, is that we filed the objection after withdrawal of the objection by 2 persons.
Let's see the impugn order.
Madam, let's just. Lord, I come to page number 22. It's a short order.
Yes.
Page 22. May I read, my lord?
Just by the, okay.
Well, since the application filed by Sri Tawi Sangma to register Nokmaship of the Sansuch, and also peruse the spot inquiry report dated Sansuch submitted by the Mozaddar Sansuch. On perusal of the spot inquiry, it is found that the Mozaddar of Sansuch along with Mandal Sansach, has visited the spot after observing all necessary formalities with the help of Sri Marak Sansach, and accordingly they have recorded the statement from both sides. It's learned from the report that objection of Sri Sansach has withdrawn their objection and complaint on Sansach and Sansach respectively. Further, it is seen from the report that after the inquiry, Sri Tasang Sangba, is the petitioner, my lord, has filed a complaint objection dated Sansach. So after withdrawal of those complaints, I filed. This court also of the opinion that the petition of Sri Sangma deserves to be allowed because in the spot inquiry report it is clearly stated that Sri Nimi Sangma, yes Sangma, who is a present female Rukma of Sansach and such, being without any issue, children has adopted Sri Nipulan Sangma private respondent by way of adoption following the custom and practices of Garos, and they rightfully deserve to be registered as a Nogma. And this application being placed after observing all the necessary formalities and has placed a petition through Sansach, one of the to register Sansach, and her husband Sansach as Nogma of Sansach has fulfilled all the customs and practices of Garo in regard to the registry of Nogma. And as far as the complaint objection filed by Tasing Sangma is concerned, he has submitted only after the inquiry and after the withdrawal of the original objector, and therefore I do not find any merit. And on further perusal of the record, it is found that Tasing Sangma was present in the meeting place in regard to the register Sansach, and her husband Sansach Marak is Nogma along with the applicant and other clients member. And for the same, I do not find any weight in the complaint filed by the Sangma after inquiry, and not the satisfaction of this court to entertain the same. This court find it fit to dismiss the objection complaint filed by Sri Sangma and Sansach on being withdrawn, and the complaint objection of Sri Sangma for one of merit without abuse.
Now you file an appeal against this.
Now, my lord, I file appeal. My lord, appeal is, my lord, I filed the appeal, and after this order they register, and I file appeal, page, my lord, 28. I filed the appeal. I've taken the ground that no issue was framed, merely filing objection after withdrawal by another 2%. They cannot be the ground.
After objections withdrawn, after inquiry was done, then you came with a complaint.
Yes.
Why is the complaint not prior to that?
Well, that we were not aware. But we were not aware. The earlier 2 persons came forth from the client, and they faced the pressure. Therefore, they withdrew. Now, this is the appeal I prefer.
He was there in the inquiry,
and
that has been recorded in the,
that you were there before the inquiry.
No. On the inquiry, I was not there.
Then the second the order. How are we to dispute that?
That we did.
To go into that.
Now, Lordship, may I see the procedure, my lord, whether it deserves to be properly tried. Thereafter, my lord, what happened? My appeal file, and the appeal was disposed of by page 40.
Yes.
40. My lord. I'll come to this para 3 to save Lordship time.
Yes.
From the recording, it is also clear that Sri Nipulan Sangma is adoptive daughter of Sansach Nogma. She has no female issue of her own, hence adopted Nipulan Sangma from her close relatives. Appointment of respondent number 2 and 3 was initially objected by Sri Sansach, but later on they had withdrawn their respective objection. However, immediately after their withdrawal, present appellant Sansach has filed objection in his individual capacity, but EM did not consider his objection, hence passed impugned order. Against the majority decision, the above 2 individuals have objected, which was subsequently withdrawn. After their withdrawal, only the present appellant had attempted to revive this objection by filing his separate objection petition, but no resolution or support from the land members had been submitted in his objection petition, which is indicate that this objection is in his own individual capacity.
So no authorization also.
Oh, my lord, it doesn't require, my lord. The customary practices, my lord.
No. If you see, you know the judgment of Dore Sangma, it's fundamental principle of judicial procedure have to be followed. So even on the part of your appellant also, if you have to follow by the fundamental principle of judicial procedure, that means that if you are to prefer an appeal petition, there has to be, you can't prefer an individual capacity. But it's been recorded there.
No, my lord, I also relied on Dore Sangma. Exactly.
Fundamentally, what do you mean? Now inquiry has been done. Now the thing is that it's not a question of Nokma dispute between two Nokmas. Yes. Correct? With regard to genealogical, there's no whisper here who should be the rightful one. You're only questioning their appointment.
Yes, they did.
See, so your case stands apart from Dore Sangma. Dore Sangma can be where there are 2 family lines, uterine lines, whatever, where they dispute. And so the dispute founded on some, on because they have a geographical chart which goes to like 1920, 21 or prior to that. So when there's dispute with regard to the branches of family, then at that point of time, you can't just dismiss an application by a person who seems to have a vested right to be a Nokma. And that time you have to go through the entire gamut. Now in this, what objection has been done? Withdrawn. Inquiry was held, you were present, you didn't take part. After the entire proceedings had been closed, then you came forward and filed a complaint. Naturally, your complaint will be dismissed, and the CM has gone one step further to say that this is not, is not supported by any authority, authorization by the Maharis or by the Charas or by the
My lord, my humble submission.
You could have shown one small paper showing that the Maharis or the Charas, the Chachis, all those of that particular Aking, this Okapara Aking, had entrusted you with the responsibility of objecting to the, then maybe you have some case. Otherwise, on the face of it, no.
Kindly have my affidavit, Malord.
I will find out my
application, Malord.
Address is also from a different district altogether, not staying in the Aking also. There is no averment. Writ petition address is in a different district altogether.
Now, according to you, who should be the Nokmas? That we want to hear. According to not you, I mean the petitioner, who should be the Nokmas? Who should, if you want to apply Doris Sangma, then you come with the name, specific name of those people who should be rightful Nokmas.
Well, Lordship, kindly see page 29
of your writ petition.
Of my writ petition, well,
yes.
The averment is there.
I think this is averment will not help, Mr. Chari. So. If you adopt it as per Gari customary law, that means you should be you will be the Nokna, I mean the heir. Yes. Even if you have granddaughters, doesn't matter. But if there's another case where I think we pass judgment here only. With regard to the same allegation, though this person deserted her parents, whatever he went off, then they took in what's it called? The principles of this is what is the term?
Lordship is referring to
adopted daughter. What's the term in Garo? What do they call it?
They basically call it Nokna, my lord.
Nokna, no. There's not a term for adopted daughter. I think I saw it here in the order.
Is the clan members.
Lordship, page 29. In my appeal, we have highlighted the factual position of the parties. Para 6 onward.
Now come to para 5. What do you see in your appeal petition?
Well, para 5.
Yes.
On the objection petition being withdrawn, the appellant was substituted as an objector for registration of.
Where's substitution? By whom?
Well,
by whom?
My lord, that is the gland, my lord.
Where is that?
That is the gland, my lord. That is one of the averment. And Lordship travelled down to para 8.
No. Why have you made this averment in your appeal? That on the objection withdrawn, appellant substituted. Now, where have you substantiated that?
But that was the resolution of the gland, my lord. According to me, my lord, all this matter will come to for trial during the trial inquiry, my lord. Normally, the normal this.
Yeah, you have no locus also.
Doris Sangma has made it very clear.
Doris Sangma only says that you observed a fundamental procedural procedure, like you frame issues and you take up the matter.
My lord.
This case doesn't deserve that.
That will come in family tree para 8, my lord.
There have to be materials that deserve a proper.
Para 8, my lord.
Where's the
family tree also have highlighted?
They
page 29. Page 29, para 9 minutes. Question of merit rises the general tree of sunset may be reproduced herein under.
Yes.
So genealogical tree also highlighted by the.
Were you present in the meeting? Are you one of the residents of the King?
Did
you take part in the meeting where they resolved to to apply for registration for 5 and 6.
There was the contention of the party. The client never adopted a resolution to appoint the private respondent.
What about the next one signed by all these people of the affidavit? Have you counted that?
My affidavit.
Affidavit by 5, 6, and 7. See? Page 13, 11 or 13. He's got more than 196 signatures from the village of this Opopara.
No rejoinder has been filed.
No rejoinder is filed.
Order dated 6 March 2024.
See, look at this application.
Page number, my lord, refer to page 11.
18 of that affidavit.
Yes.
Page 18 of that affidavit at serial 117. His signature is also
yes,
there.
Mr. I'm so sorry. You have to come with, substantial materials to support your case to apply Dore Sama.
Lord, I do rely on the Dore Sama case.
How will you rely on you're total outsider? You're total outsider. You're nowhere in the picture. I'm not giving you one scrap of paper to show that you have other people or you have any right to Nokma post.
My lord, that will come during the trial. May I just refer that Dore Sama, my lord. I'll just give that judgment.
Sorry, not look at Dore Sama.
It is very clear, my lord. Issue is going to be framed.
No,
and evidence
no. In certain cases, yes. Not in this case, Mr. Changre. So please. You are an outsider totally. You have no material that is apparent. If the materials were shown in writ petition that there is some, cause on your part, yes, why not? But if no materials reflect that, why? Should you remand a matter for retrial? For what purpose? For the same result to come out?
My lord, according to me, with due respect, the complaint deserves to be addressed.
Complaint deserves to be dismissed. They have already.
So my humble submission is order passed by member as well as CM is not in accordance with the Dore Sama.
Okay. Let's take down. Oh, sorry. Anything to say?
Lordship, we have stated in the affidavit that he is just a complete stranger to the
Where is that?
objection. Lordship will kindly have our affidavit. Page 6, my lord.
Your affidavit?
Yes.
At page?
Page 6, my lord. Paragraph 17 and 18. It's the sum up, my lord. The adoption was not disputed by anyone. And the adopted daughter has the entire right, my lord. And
no, that's true.
She is the daughter of the last recorded Nokma.
No. One thing which your case, which are so, is that your client, your petitioner, he has no legs to stand on apart from rejection. That's all. Made after inquiry, he has not forwarded any. He has not said that from the genealogical line or line of the person who nominated the Nokma. Also, there are other people who, and there are documents to show that they dispute that, like that document given by them in Lecture 1 by the respondent 5 and 6. Nothing.
But Lecture 1, I have seen the annex by the.
Why did you file rejoinder to it?
143.
Why did you file rejoinder to it? There's no rejoinders. Accepted.
My lord, the issue is relating to procedure, my lord. The fairness.
Also, my lord,
and this court cannot
if your
enter into
lordship
that
sees the
merits
application,
of the case, evidence of the matter.
If your lordship sees the application, which is my annexure
You're going
1,
procedure only, yes.
page 12.
Procedure only.
Yes.
In the meeting of the Maharis, my lord, on 4th of January 2020, he was present. My lord.
Yes.
Where's
serial
that?
number. Kindly have page
18
of your affidavit.
Of their affidavit.
My affidavit. My lord.
Okay, let's note that down then.
Look at annexure 1, starting from page 11. This was what is my this was my application, my lord. I have enclosed name of all the persons who were present in the meeting of the Maharis, my lord. At page number 18, which is the handwritten.
Serial number?
My lord, page 20.
Yes.
Page 20. Tasing Sangman, number 4, my lord, 143. This is the petitioner, my lord. Now this is on 4th of January, my lord. The objection has been filed in March, my lord, after the inquiry was completed by the revenue officer.
Noted that, yes.
Yes, my lord. And in between this, my lord, objections were filed by 2 persons. Those objections were withdrawn. He waited for all of that, my lord. Then after the inquiry is complete, then he comes and objects, my lord.
Yes.
My Lord, I'll just point out that Annexure 1, there is no resolution adopted by the Mahari, the members of the clan. The only signature is attached.
Letter, covering letter, with reference subject said about order to inform me that after the death of my husband, I, along with the Charas and Maharis, held a meeting on 4/2020 in Nokma's Kachari. In the meeting, decided to appoint. If that's not a resolution, what is it?
This is the forwarding letter.
No, what is it?
The minutes of the Mahari is not there.
What is it then? This.
My Lord.
What is it then? If they sign on this forwarding letter, what is it?
My Lord, there should be a resolution to support the
Please,
forwarding
Mr.
letter.
Chare, so there's a limit to pressing a case also. Yes. You're a senior counsel. Yes. Heard Mr. H. Chandra, the counsel for the petitioner, assisted by so and so. Also Mr. S. Deb for respondents number
1 to 4.
1 to 4, and Mr. Flino appearing for respondents
5 to 6.
5 to
or 5 to 7. Sorry.
5 to 7. Stop. Next paragraph. The writ petitioner. The writ petitioner, who are you, he said? You're not you're just a Mahari.
Member of the clan.
That agreement also is not there.
Member of the clan.
Where is it in your writ petition? Where have you said, where is that? Where in the petition have you said who you are? That will show your case, at least the slight locus you might have with regard to object to any appointment. Where is that, Mr. Also? In the petition? You only see you're a Burfet of India. Where's the government?
Well, I'll try to
that you're a member of so and so, you've stated that you. Where's that?
Well, I'll try to find out.
I think that should have come to the petition, that's who you are. Where is the state respondent so and so? Respondent married. It's not there, I think. It's not there, Mr. Charesa. You not said who you are. Because you understand that this is a case involving a customary office. And to question it, do you hold the orders of any authority, you have to show who you are to. Yes, at least to put your foot in the door.
That is true. That is true.
No, but where have you have not said anything. Why? Because we are.
My Lord, if Lordship permits me, page 29, para 2 of the memo of appeal.
Yes, no, we're not going to memo appeal. In your writ petition before this court, at least
there is no specific.
That
yes,
kindness to at least put before this court that who are you coming to invoke 226.
Right.
It's not a question of appeal under Section 82 of the Validating Act.
Right. It's a rich jurisdiction. I know.
That's why it's exercise powers of 226. Who are you? Which way has your right been infringed upon?
Only the case of the petitioner is he is authorized by the members of the clan. That is his statement in the memo of appeal. It would have been more elaborate in the writ petition. I guess.
No, it's that. That is also yes. Anyway, take down the writ petitioner. First paragraph. What is that? Yes. So next paragraph. The writ petitioner has sought to invoke the writ jurisdiction of this court to question the appointment of respondent number 6 and 7. 6 and 7, right?
Yes.
As Nokmas of Okapara, OKKAPRA, Songacham, next word SONG, then again GITCHAM, Aking, Damalgre, South Garo Hills. On only one ground, that the complaint filed by him against a said appointment was not dealt with by the respondents number
2 and 3.
2 and 3. Was not dealt with by respondent number 3 in a correct manner, and that the non-adherence of the response 2 and 3, is it correct to say to the principles as enunciated in Dore Sangma?
Yes.
Yes, that is 1989.
Yes.
But one DLR page 2, page 180. What page?
Lordship has remembered.
1988.
1988, yes.
2
GLR. Yes. Mr. Chari, so not that, but then you see, in my practice, we've, like my practice before 120 years, the GLR 192 GLR is, we've handled a lot of these matters. That's the thing. Thomna? To the same. To him, I'm sure before that. And that the same were disposed of without adhering to the principles as enunciated in the judgment of Smriti Dore Sangma DORE, Sangma and others versus Chief Executive Member GHADC and other connected matters, which is reported in 1988 within bracket 2 GLR 120. Stop. Next paragraph. A perusal of the impugn orders which find place at verse 1.
My Lord is referring to the Dore Sangma case.
No, impugn orders in your petition.
Impugn order, my Lord. Page 22. It's the order passed by the Deputy CM.
Appellate court's orders at page
No, first order.
First order is page 22.
22.
dated 21st April 2022.
On approval of the impugned orders dated 21 April 2022, passed by the Deputy Chief Executive Member in charge Land Revenue, and the appellate order therefrom dated
page 40, 28 June 2023.
Dated 28/6/23, passed by the Chief Executive Member. It is seen that the writ petitioner had objected to the appointment of respondents number 6 and 7 after some initial objectors had withdrawn their objection and complaints, and also after an inquiry had been gone into by the revenue authorities with regard to the application for appointment of NOCMA to the officer of NOCMA by the respondents number of respondents number 6 and 7. Stop. The order dated 21st April 2022 is reproduced here and below. Stop. Similarly, the order dated 28/6/23 is reproduced here and below. Stop. From appraisal of the findings, sorry. In short, as can be seen from the orders above, is that the writ petitioner has no way established his locus or on whose authority the complaint was filed after the entire proceedings have been concluded. That is the process of the application of 6 and 7, the withdrawal of objections by initial 2 objectors, and also the furnishing of the inquiry report by the revenue officers of the District Council. So, from the the respondents, materials have been annexed to show that the claim for the appointment of the response 6 and 7 is based on the application of Garu customary law, and further the application for consideration of appointment as furnished with the affidavit, as submitted before the District Council, which is Annexure 1 of the writ petition, has been with the support of the CHRAS and Maharis, pursuant to a meeting held on 4/1/2020 and 196 signatures have been appended thereto. Stop. It has also been brought to notice of the court that the petitioner himself was present in the meeting held on 1/4/2020 and had signed the document at serial 143. So it is to be noted that this annexure there has been no rebuttal or any rejoinder affidavit filed to the same. Stop. What else, Mr. Deb? What do you say?
Lordship, as far as the District Council, my lord, we have followed the due process after recording of the issue statements we have.
Yes, from the side, from the side of respondents, no, from the side of the official respondents, it has been submitted that due process, taking into account the application customary law, has been followed, and that there is no illegality or irregularity whatsoever in the appointment of respondents number 6 and 7. Therefore, this court, on the basis of the submissions, on the basis of the materials as placed, has firstly noted that the writ petitioner himself in the writ petition has not disclosed as to who he is, what is his interest, and what reliefs he is entitled to in assailing the impugn orders. Stop. Nowhere has it been reflected as to what would be the outcome if, nowhere has it been reflected in the writ petition as to any authorization to file a complaint after the matter had been concluded by the respondents. And as observed earlier, the only ground is that the procedures should have been, there should have been a more detailed inquiry into the complaint. Stop. In this backdrop, in the backdrop of these facts, and view the fact that the writ petitioner has neither disclosed his right, or disclosed his locus, nor reliefs he is entitled to, nor file any rejoinder to the affidavits filed by the respondents, it clearly appears that there is no merit in the writ petition, and the impugn orders suffer from no illegality. Accordingly, the writ petition stands dismissed. Obliged. Sorry, Mr. Riso, but your writ petition, you did not disclose anything.
But there is it is quite sketchy. It could have been more elaborated while drafting the writ petition.
Delay and locus.
Yes, thank you.
Much obliged.